Good morning. Welcome to Webb County Court at Law 2. I'm Victor Villarreal, judge of your Webb County Court at Law 2. This is the family law docket for Thursday, March 5th, 2026. The time is now 9:10. Court is now in session. Assisting us today are Cecilia Rodriguez, court administrator and interpreter. Ms. Cynthia Flores is the family law court coordinator. Video conference co-hosts this morning include Mr. Lopez, Ms. Ramos, Mr. Hernandez. These proceedings are being electronically recorded. Everyone is instructed not to record any portion of these proceedings. Only a court reporter may provide the official record. As with all proceedings, violation of these instructions are subject to contempt hearings. If you're joining us online, you're instructed to act as though you were in court, because you are in court. The rule here is simple. If you would not do it in person, don't do it online. For example, do not operate a motor vehicle. There is no smoking, no chewing gum, wear appropriate clothing, and always exercise. Proper courtroom decorum. The court will now call the cases in the order of appearance of counsel, first those in person, and then those online as measured by your login times. Ms. Flores, Ms. Rodriguez.
Case Your Honor, the attorney Jose Salvador Reyes, page 2, number 5.
Daniela Espericueta versus Oscar Eram Ramirez, cause number 2019 FLA 1411C3. Court marks Mr. Reyes present in person, Mr. Villafranca present in person. Nelly Salazar, are you present? Court finds the attorney ad litem not present. Is anybody here on behalf of the Attorney General's office?
Good morning, Your Honor. Catherine Garcia. We are not making an appearance on this case, but I am available to assist the court if needed.
Very much appreciated as always. Thank you. Mrs. Espericueta, Mr. Ramirez, are you present? Court finds Mr. Ramirez present in person. He is in the audience section of the court. Daniela Espericueta, are you present?
She's not present.
All right, counsel, go ahead.
We filed a motion for a continuance because the guardian ad litem has not filed the report of her social study. And I spoke to her 2 days ago and she indicated that she has a draft of it, but she was not going to file it by today's hearing. We filed an agreed motion for a continuance asking 30 days from today. And keeping in mind that April 3rd is the Easter weekend. So I'm asking for sometime from April 6th through 10th.
No objection.
I mean, after Easter.
That's not it?
You're asking for after Easter?
Yes, after Easter weekend.
Understood. I reviewed this before today's hearing. I reviewed it yesterday. I just didn't sign off on it because I was hoping to ask Ms. Salazar some questions. But if she's not here, the court will approve this request by agreement as requested. Give us a setting after Easter weekend, please.
April 16th at 2 p.m.
Right there.
Anything else for Mr. Villafranca or Mr. Reyes?
Brother, Your Honor, may I please be excused?
Have a good day. You're excused.
Next case is attorney Alfonso Ramos, page 2, number 4.
Elsa Gomez versus Andres Jorge Gomez, cause number 2018 FLA 2421C3. Court marks Mr. Ramos present in person, Ms. Garcia present in person. Good morning to both.
Good morning, Judge.
Elsa Gomez, Andres Gomez. Any parties present?
Ms. Gomez is present.
Court marks Ms. Gomez present in person in the audience section of the courtroom. Andres Jorge Gomez, are you present?
He should be online, Judge.
Yes, I am, sir.
Mr. Gomez, I'm going to ask that you turn on your video, please.
Sorry. Yes, I am, Your Honor.
Welcome to court, Mr. Gomez. The court marks you present by video conference. As you can see and hear from your device, your lawyer is present in person. Ms. Garcia, Mr. Ramos, go ahead.
Your Honor, we're here for a pretrial hearing. We don't have anything to pretry right now. I believe we have a final hearing at the end of March. We are trying to schedule a meeting with the Attorney General to try and calculate numbers, Judge. Ms. Catherine Garcia has made herself available tomorrow. Unfortunately, Mr. Ramos is going to be out of town. And then I do need to provide him with my client's current financial information. So we have been in touch with Mr. Schamberger as well, and he has made himself available next week. So we're hoping to meet with them and be able to have something done in the next few weeks to come to agreements, or at least get the numbers. It is what it is, right, Judge? With the Attorney General. And I do have, with regard to spousal support, my client is going to make another payment on the outstanding spousal support in the amount of $2,000 on Friday, tomorrow. So I will coordinate with Mr. Ramos to get him another certified check.
Mr. Ramos?
That's the agreement, Judge, also present for Ms. Gomez, Ed Dankos, Judge, just for the record.
Court marks Mr. Dankos also present in person.
So if hopefully we'll come to agreements with regard to the pending matters, and if not, then we'll have to have a hearing.
Couple of questions, Ms. Garcia. Several questions.
Mhm.
The financial information that you will give to Mr. Ramos includes
Tax returns and current pay stubs for the last few weeks, months, to show when he makes.
and this case is set for final hearing April 28th. How much time do you think would be reasonable to give that information to Mr. Ramos?
Oh, I can do that by next week.
Preferably before a meeting with Mr.
Yes,
Schamberger
definitely.
is the idea,
Yes.
Judge.
Yeah, I think he said next Tuesday or Wednesday. So yeah, I'll get it and send it to him no later than Monday.
All right, sounds great. For the court has heard there's nothing to pre-try. Just so that you know, Ms. Garcia and Mr. Ramos, the court will soon be circulating some proposed rules, policies, orders, and forms to standardize a lot of these things and to
Mhm.
bring it into square alignment with the local rules on family law cases. Hopefully that'll help. And I was trying to gauge,
Mhm.
but I certainly appreciate your efforts, Ms. Garcia and Mr. Ramos. I'll call this case on April the 28th at 2.
Great.
Thank you to both.
Thank you, Judge.
Have a great day.
You too.
Thank you, Judge.
Any other cases for either counsel?
That is all for both attorneys.
Everyone is excused. Have a great day.
Next case, Attorney Brenda Anderson, page 5, number 14.
Maria Teresa Cadena versus Rolando Cadena, cause number 2025 FLB 1347C3. Court marks Ms. Anderson present in person, Mrs. Cotto present and participating by video conference. Good morning to both.
Good morning, Judge.
Maria
Madam
Teresa Cadena, Rolando Cadena. Is any party present?
Madeline Escoto for Mr. Cadena, Judge. He is not present.
And Brenda Anderson present for Maria Teresa Cadena.
Court finds no persons are present. This is a final pretrial hearing. Mr. Anderson, Mrs. Cotto.
Your
I
Honor,
don't have anything. Go ahead.
we don't have anything to pre-try at this time. However, I did receive discovery responses. Was it yesterday or?
Yesterday.
Yesterday. So I have not reviewed them yet. So if a motion to compel is necessary, I want to reserve my right to still be able to file that motion. Once I review the discovery that was received. So I don't know that we need another final pretrial, but if I need to file a motion, then I'll file a fiat with it to request another setting before our final TOM.
And my response, Judge, is that if she thinks that the discovery sent is deficient per the local rules, she needs to confer with me
Yes,
so that I can update that, Judge, before filing any motions.
yes, of course, I would. Yeah.
So okay, two things. First, there is a request, and I think this is Mrs. Cotto's request for mediation. Are you moving on that, Mrs. Cotto?
Judge, I don't think Ms. Anderson would object to it just because we have our final court date on this case is April 2nd at 9. And I just wanted to ensure that if we can't reach an agreement, that at least we can go to mediation before April 2nd.
My client does not oppose going to mediation. I think the only issue is going to be the payment of the mediator's fees. In this case, my client receives disability. in the amount of approximately, I think, like 1,200 a month. Whereas her husband, I believe, makes over 10,000 a month. So, take home. And, so I think I wanted to confer with Mrs. Cotto regarding the mediation fees because my client cannot afford, to pay the mediator.
Response?
Judge, if we can confer on this issue and we'll submit an agreed order with the name of the mediator. I dispute some of the facts that that Miss Anderson has placed on the record as to what my client earns, but
I tell you what, let me do this, because if there's an agreement to mediate and because there's a short window, and my concern is that Mrs. Cotto and Miss Anderson are very competent professionals, but by that same token, very busy professionals. My concern is that since you only have a month to mediate, that I'd rather sign this right now to get that process going, because both of you and all of us are very busy. So I tell you what, first question, Ms. Anderson, Mrs. Cotto, off the top of your head, are there one or two persons that you can agree to mediate this case with?
I believe so, Judge. I would think Judge Hale or Miss Cigarroa or Miss Hayes.
We would agree to either one, Judge.
And number two, Judge, their house closes in March. So both parties will have enough funds to pay a mediator if we need a mediator. I just looked at the email from Miss Wright, who's the realtor. They're set to close on the 23rd. I don't know if Miss Anderson saw that.
I did see it. I wasn't sure about the date, but yeah. So if if she has the funds beforehand, then of course she'll have funds.
Right, that was the second issue that I was going to address, and assuming everything is true, but may not be as presented, what the court does in these situations is the court, to be equal, fair to all, will assign 1/2 of the mediator's fee to all persons, and then encourage you that if the facts as stated to the court are correct, then perhaps at mediation, those fees can be covered by the sale of the home or by some other means. All right, so the court has written in Judge Hale, comma, senior district judge, in the blank 1/2, in the next blank 1/2, each party until further orders of the court. The court has signed that original and tendering the original signed order to mediation to the clerk's office. That takes care of the mediation. Regarding the request for discovery, obviously, it isn't presented at final hearing, so it's a moot point until raised. And then at that point, the court needs to hear any good cause as to, whatever the issues are. As I mentioned to Ms. Garcia and Mr. Ramos at the previous setting, Ms. Anderson and Mrs. Cotto, the Zoom will soon circulate proposed orders, rules, policies, and standard forms so that this becomes almost, I don't want to say automatic, but just much more standardized to help the parties. But thank you for all your efforts. I'll call this case on April the 2nd at 9. Anything else on this case, Ms. Anderson or Mrs. Cotto?
Yes.
No, Judge, I look forward to conferring with Miss Anderson, Judge.
Very well.
Likewise.
Ms. Flores?
Next case from Ms. Anderson, page 7, number 20. Mrs. Cotto's further down the line.
Ms. Blanca Ruby Arellano versus Pio Arellano, cause number 2025 FLB 1711C3. Court marks Ms. Anderson present in person. Blanca Arellano, Pio Arellano, are you present?
For the record, Your Honor, Brenda Anderson present for Blanca Arellano. She's the petitioner.
Speak into the microphones and tell the court, are you Blanca Arellano?
Yes.
Court marks you present in person. The person to your left is your lawyer. Are you Pio Arellano?
Yes.
Welcome to court, Mr. Arellano. The court marks you present in person. Mr. Arellano, do you have a lawyer?
No.
Will you be going forward today without a lawyer?
No, precisamente eso vengo de la demanda porque a mí me enviaron un estado ausente. Yo no puedo ponerme ahorita por el que tengo abogado. No, that's why I'm here today. I was served with the lawsuit when I was in prison,
And that's why I'm here, because I have the ability to have a lawyer in the city.
And the court's question is, will you be going forward without a lawyer? Or are you asking time to hire a lawyer?
Quiero tiempo, o sea, vengo a saber qué decir, aquí, qué decir, qué decir.
I want time. I want to know what the procedure is and what she's asking for.
Ms. Anderson?
Your Honor, this is the second time that the divorce was filed.
I see that.
And so my client would like to try to get this done as soon as possible, but I do understand this is the first setting and the policy of the court is to grant one continuance. So we understand that rule. And so whatever date is next available, what we would ask that be the final trial date.
Understood. Ms. Anderson, just to confirm, you're just asking for a final hearing date, correct? You're not asking on behalf of your client for any temporary orders?
No,
So, Mr. Ariano, what Mrs. Ariano's lawyer is telling the court is that she understands the policy of the court, that she does not oppose your request for time to hire a lawyer, but that she, on behalf of her client, will object wholeheartedly to any other request for more time. Which means that it's very important that if the court gives you time, you use that time wisely to look for a lawyer, to talk to a lawyer, and to hire a lawyer if that's what you choose to do as soon as possible, not even a day or a week before the next hearing. Do you understand this?
Entiendo perfectamente, o sea, solamente que ahorita, en este momento ya sé lo que está pidiendo y a eso vengo a tratar de atender esta cita. So, cuando estaba yo ausente, no podía hacer nada.
At this moment, that's why I'm here. I'm trying to figure out what is required, what they need from me. And when I was out, I wasn't present, I'm putting a follow-up.
It's clear to the court that you don't know what's going on. So let me give you some time to hire a lawyer. Ms. Flores, give us a final hearing date, please.
April 16th at 2 p.m.
April 16th at 2. Ms. Flores, does the court have Mr. Ariano's email address?
Yes, Your Honor.
All right, be on the lookout in your emails, Mr. Ariano, because if the court needs to send you any notices, give you any information, it'll go to that email address. Similarly, if Ms. Anderson needs to send you anything, it'll likely be to that email address. Do you have any questions for the court, Mr. Ariano?
Ninguna nada más para quería estar seguro que era el.
None, that was it. I just wanted to know what's going on.
Anything else on this case, Ms. Anderson?
no, Your Honor.
Mrs. Ariano, do you have any questions?
The only thing I'm asking is what is fair for me.
You have the court's assurances that in any and all situations, the court will do what the law requires and do a just and right decision. I guarantee you both. All right. And I wish you both very well. Have a good day. Any other
Next.
cases?
Yes, Your Honor. Next case from Ms. Anderson, page 9, number 24.
Vanessa Medina versus Aizar Conrado Medina Jr., cause number 2026 FLA 263. Court marks Ms. Anderson present in person. Mr. Arce, Ruben Arce, are you present?
Mr. Arce called, he was going to be at the 341st, Your Honor.
Yes, Your Honor, I believe he's in another courtroom. I don't mind waiting and texting. However, I do think it's gonna be an announcement, but I'll just confirm with him and get his permission to make the announcement if I can.
Without knowing anything else, I'll mark this as the first contested matter. Are you Vanessa Medina? We'll begin Spanish language.
¿Es usted Vanessa Medina?
Sí, aquí estoy.
Yes, it's me.
Court marks you present by video conference.
El juzgado la marca presente por videoconferencia.
Your lawyer is in another court,
Su abogado está ahorita en otro juzgado
and Mr. Medina's lawyer is going to try to talk to him before we go forward.
Y el abogado del señor Medina va a tratar de hablar con él antes de continuar.
Stand by, please.
Permanezca, no se vaya. Ahorita regresamos.
Gracias.
Thank you, Judge.
Thank you.
Next case, Attorney Nathan Chu, page 3, number 8.
Ashley Anali Martinez versus James Castañeda, cause number 2024 FLA 1863C3. Good morning, Mr. Chu.
Good morning, Judge.
Court Martial present in person. Mr. Arce is not present. Mr. Julio Garcia, are you present? Court marks Mr. Garcia not present. Ashley Martinez, James Castañeda, are you present? Court finds the party is not present. Mr. Chu, go ahead.
My client should be online, Judge.
James Castañeda, are you present? Court finds no persons are present. Mr. Chu?
Judge, either way, I did send a proposed order, but I have some mistakes and I have the court's instructions to fix those mistakes, Judge. The only one that I do want to address would be number 4. And I'll probably have to change the language to input it there because the parties have agreed to not have child support because it's 1 week on, 1 week off.
It doesn't matter. The court pronounced and rendered. So you need to put it into the decree. I need to sign it, and then you need to come back and have the redo. So whatever gets pronounced and rendered, and then the parties agreed to something else, it doesn't matter. It's been pronounced and rendered. The party's going to agree to whatever they want.
No,
but
we agreed it on the record, Judge, that there would be no child support and that it was just going to be an offset.
I don't have that in the court's notes. I have. Do you have my notes, Ms. Flores? Court ordered child support in the amount of $1,080. Let me confirm. Does the clerk have the clerk's notes entries?
Let me go ahead and check, Your Honor.
I think the court verified using the court notes and the docket entry, Mr. Chu. But if I'm wrong, I'm happy to sign the decree as is. But we in the court's review of the proposed decree, we noticed that there was several things that were different from the court's notes and what was pronounced and rendered. Court's notes say split custody Monday to Monday, $1,080 in child support.
Your Honor, if I may, the clerk's notes, physical notes to
Yeah.
have child support ordered in the amount of $1,880.
Judge, then I will make the changes and then thereafter we'll.
But I do have an agreement to stop. I don't know what that means. I don't recall. So that was why the court did what it did, Mr. Chu. It was the court notes, and then the court reviewed the docket sheet, and it was just different. And I'm wondering now if something else didn't. But that's just such a huge gap.
Yeah, I believe we did read into the record, Judge, that there is split custody and there's
That-
no child support except for the difference in wages, so there's gonna be an offset. So that's,
It's very hard to understand how the court staff and court clerk heard something different. I guess that's what's part of the record. So just put it into the order, and if you would like the court to go back and to review the actual transcript, just file it in writing, and I can do that. And then I can make a decision based on that, based on the actual words that were said, but just based on the notes from everyone. We're all
yeah. I
think
mean,
something different.
Or I can just make the changes, Judge, and then if I can get Mr. Arce to sign off on it, it should be sufficient.
I think you're right. I think you're right. But if you want us to review the transcript, just file it in writing, and I can quickly go back. But if not, just make those changes. Give us an order's due date, please, Ms. Flores.
That'll be March 30th at noon by submission.
All right. Any other cases for Mr. Chu?
Yes, Your Honor. Page 5, number 12.
This is Miguel Angel Cuenca versus Brenda Marie Cuenca, cause number 2025 FLA 1624C3. Court marks Mr. Chu, present in person, Mr. Cantu, present in person. Good morning to both.
Yes, Judge. Good morning, Judge. Good morning, Judge. Nathan Chu present for Ms. Brenda Quanka. I filed an appearance of counsel and also a motion for continuance, which counsel has agreed to, Judge, because I've just jumped on board with this case. That's correct, Judge.
Are you Miguel Cuenca?
Yes, that's him, Judge.
Yes, Judge.
Welcome to court, Mr. Cuenca. The court marks you present. You're participating by video conference. As you can see and hear from your device, your lawyer is present in person. Brenda Cuenca, are you present?
She is. She just hasn't started her video.
I see. Court marks Ms. Cuenca's device logged in. All right. By policy of the court honors the request. Ms. Catherine Garcia, is the AG's office making an appearance in this case?
Good morning, Your Honor. Your Honor, we do have a case open. I can make an appearance, even though both parties are represented by counsel, but the AG's office will make an appearance.
All right, well taken. Are you Brenda Cuenca?
Yes, I am.
Welcome to court, Ms. Cuenca. Your lawyer is present in person. You are participating by video conference. Ms. Flores, would you give us a trial on the merit setting, please?
April 16th at 2 p.m.
Judge, I have a case letter on file from the 11th through the 18th.
Give us the next setting after that, please.
April 28th at 2 p.m.
All right. Anything else on this case, Mr. Cantu?
The only other thing, Judge, is, I don't know, Judge, if maybe the court could give us, I know Mr. Chu filed a motion for some temporary orders. I don't know, maybe the court could entertain and give us a setting on some temporary orders, or if we can maybe submit those. We have a home that we kind of want to see if we can maybe sell. I think both parties are in agreement to sell the home, but I know I only filed those. I wouldn't be opposed to at least setting some temporary orders.
Mr. Chu, you filed for temporary orders?
I believe so, Judge, but, Judge, I guess if I do need a hearing, I'll submit a fiat.
Sure.
I'll try to confer with counsel first to see if we can just have a written agreement as to that effect.
That's fine.
Sounds very reasonable. Thank you. Mr. Cuenca, do you have any questions for the court?
No, Judge.
Mrs. Cuenca, do you have any questions for the court?
No, Judge.
Keep in contact with your respective lawyers. I wish you both well. You're excused. Any other cases for Mr. Cantu or Mr. Chu?
Mr. Cantu down the line. Another one from Mr. Chu is page 8, number 23.
Samantha Lee Ramos. This is in the interest of Samantha Lee Ramos. Cause number 2025 FLK 992C3. Court marks Mr. Chu present in person.
Good morning, Judge Nathan Chu present for Ms. Samantha Lee Ramos. It's a petition to change the name of the child, her son.
Are you Samantha Ramos? Is this your client?
Yes, Judge. Unmute.
Court marks Ms. Ramos present by video conference. A couple of things in the court's review of this case, Mr. Chu. Is there service on the father?
Yeah, we did a publication with OTA website, and that was returned December 29th of 2025.
And it looks like, but I don't know that that suffices. It's with the Office of the Court Administration. But isn't the requirement either by actual publication, like in a newspaper of some sort? I mean, it's the clerk's office. Proof of service on file?
It was posted on the OCA website, Your Honor, from November 25th to December 29th. Whenever there's a statement of inability on file for the person that's filing, it just gets posted on the OCA website and not by LMT.
Oh, I see. And in this case, there is a statement of inability.
There is.
Oh, I see. Well taken. Okay. Are you Samantha Ramos?
Yes, I'm sorry about that.
No, not a problem. You're live and you are on video and audible. Welcome to court, Mr. Ramos. The court marks present by video conference, as you can see and hear from your device. Your lawyer is present in person. Mr. Chu, are you ready to go forward?
Yes, Judge.
Ms. Ramos, would you raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes.
You may lower your hand. Mr. Chu, go ahead.
May it please the court. Ms. Ramos, could you please state your full name for the record?
Samantha Lee Ramos.
And your son's name is Carlos Anthony Zapata?
Yes.
When was he born?
November 1st of 2008.
What is his father's name?
On the who had him? Like who I had him with?
Yeah,
Gi-
his biological.
Okay, Guillermo Soriano Jr.
Okay. And why is Carlos's name Zapata?
That was my maiden name when I had him.
Oh, okay. All right. And what is your name right now?
Ramos.
Okay, and you're asking the court to change your son's name to Carlos Antonio Ramos?
Yes,
Okay. And do you have other children, Ms. Ramos?
I do. He has a sister. Her name is Allison Ramos.
Okay, and it's just Allison and Carlos?
Yes.
Okay, and you want to ask the court to change his name to match your name and his sister's name?
Yes.
Okay. Are you currently married?
Yes.
Okay, and your husband is also Ramos?
Yes.
Okay, but you're not asking for a termination of the parental rights from his biological father. You just want to ask the court to change his name to reflect
Yes.
your name and his sister's name.
Yes.
Okay. Your Honor, that's all we have.
I have more questions now than I did before your testimony, Ms. Ramos.
Mhm.
As Mr. Soriano seen his son, when was the last time he saw his son?
The last time Carlos was about 4.
And how old is he now?
I'm sorry.
How old is your son now?
17.
Does Mr. Soriano provide any child support?
We do have an order, but he does not. And so I believe in the last court I had, maybe about 2022, we tried to cancel that and move forward from it. But as of right now, he doesn't provide anything.
And the next series of questions, they're not meant to pry into your personal information, but it surprises the court that you're requesting a name change for your son, not in your maiden name, but into your married name. And normally, these requests are made when a parent, I guess in this case, a stepfather requests an adoption, but there is no man here to say, I want this child to have my name. And I'm wondering if those are things that you've considered.
I did. So he is at work, and I did talk to Mr. Chu, and they were like, if to not prolong it, this was kind of a way for us to be able to make this change and
What's the
not.
rush?
Well, there is no rush because I've been waiting for a long time. I think
And I think that's the
he's
court's point. If your son hasn't seen his father in 13 years, but if he has a good, ostensibly, a really good relationship with his stepfather, then I can't imagine that there's a rush in the next 20 minutes or 1 month to do this when there's bigger things that you could consider.
Yes.
Do you think it would be in your son's best interest? 2 questions. Do you think it would be in your son's best interest to change his name to Ramos?
Yes.
Do you think it would be in your son's best interest to change his name to Zapata?
No.
And do you think it would be in your son's best interest for your husband to adopt your son?
Yes. Because he already sees him as his dad. Like there has been no one but him since he was about a year. So that's the only person that he sees as his father.
I was fishing for exactly that same information. And I was hoping that that could be the case, because if it is, then the court can find that that could be maybe in your son's best interest. So I'm going to make a preliminary finding that it's very likely that it is in his best interest to change his name, but I'm going to place this case on pause to give you some time to talk to your husband to see if that's even something he would consider, because your testimony here is it is in your son's best interest to have an adoption take place. And that's a standard that this court and all courts need to look for when addressing children's issues, is what's in their best interest. So a name change, possibly, maybe, but here the testimony is he should really be adopted. If those are the facts in real life, why not make that the case in the legal world as well? So let me give you some time to talk to your husband and your son. What grade is he in?
He's a junior.
So he ostensibly he's probably going to graduate May
Next
of
year.
2027.
Yes.
Maybe he'd like to cross the graduation stage with a new name and new family situation. And I think that could be maybe a good thing. So let me give you some time to talk to Mr. Tu, talk to your husband. And if the answers are no, I perfectly understand. I'm not fishing for one way or the other. I just need to know whatever is in your son's full and final best interest. All right. So give me a docket control conference and then a final hearing. Docket control in 30 days.
April 2nd at 9 a.m.
And give me a final hearing after that.
May 19th at 2 p.m.
So that gives you some time to thought. And like you said, if there is no rush, because this is an important matter, because your son is important and we value him, then let's do this once. Let's do it right, and let's do the best for him.
Okay, thank you.
All right, talk to your lawyer. We'll see you in April. Any other cases for Mr. Chu?
That is all for Mr. Tu.
It's great to see you.
Thank you, Judge.
Have a good day.
Thank you.
Next is Attorney Luis Antonio Figueroa, page 6, number 16.
Maria de Los Angeles Mireles versus Jerónimo Ibarra. Cause number 2025 FLB 1514C3. Court marks Mr. Figueroa present in person. Mr. Garcia, are you present? I paused and hesitated the last time I called him because I do see his name. Mr. Garcia, the court marks your device present.
Good morning.
Good morning.
We have an agreement, Judge, to ask for more time.
Is it in writing?
No.
All right.
Submitted right now.
Okay, let me place this case on pause. And as always, what I do is if these cases ever get audited, there has to be something in the record that say, for this reason, this was a good reason, cause and basis to grant the request. So let me place this case on pause.
Yes, Your Honor. Thank you.
Next case, Attorney Victor Villafranca, page 8, number 21.
Mario Alberto Valdees Jr. versus Jocelyn Ventura, cause number 2025 FLI 276C3. Court marks Mr. Villafranca present in person. Mario Castillo III, are you present? Court marks Counsel Castillo not present. Jonathan Garcia Davalos, are you present? Court marks Mr. Garcia Davalos not present. Court marks Ms. Catherine Garcia present by video conference on behalf of the Attorney General's office. Mario Valdees, Jocelyn Ventura, are you present? Court marks parties not present. Mr. Villafranca.
Your Honor, we filed an agreed motion for continuance in this case. My client, she's ill, Your Honor. She can't even speak. She lost her voice. So for that reason, Your Honor, it looks like we should be able to settle this case the way it looks. I'd like to ask the court, I get for at least 30 days, Your Honor, I was given an April 16th setting for the other case, that I have. I was hoping I could get that same date. And we should be able to settle it that day.
Anything to add, Ms. Garcia?
Nothing from the AG's office, Your Honor.
All right, what was the setting you requested, Mr. Villafranca?
April 16, Your Honor.
Court is gonna set that date, April 16th
At 2 p.m.
but before I do, Mr. Villafranca, what are the pending issues? Are they just and right divisions or child custody issues?
It's a child custody issue, Your Honor. More like visitation, not custody, Your Honor. And it looks like we're gonna have an agreement with that. And then there was issues also of a petition filed by the Attorney General's office, which includes child support. And I think we should be able to come to an agreement with that also.
If it's only visitation, has Mr. Garcia Davalos provided a report and recommendation?
Yes, he has submitted that, and we have taken that into consideration. And trying to come to an agreement, Judge, yes.
Sounds like this case is on track. All right, I'll call this case on April the 16th. Thank you.
Thank you, Your Honor. My excuse, Judge.
Good to see you. Yes.
Thank you.
Next case is Attorney Rene Cantu, page 1, number 1.
James Brandon Kaine versus Edith Kaine, cause number 2008 CVH 1081C3. Court marks Mr. Cantu present in person. James Kaine, Edith Kaine, are you present?
Yes.
Welcome to court, Mr. Kaine. The court marks you present. You're participating by video conference. Mr. Kaine, do you have a lawyer?
No, sir.
Court marks you self-represented. Edith Kaine, are you present? Court marks
Yes.
Ms. Kaine present by video conference. As you can see, Ms. Kaine, your lawyer is present in court. Mr. Cantu, go ahead.
Yes, Judge. Judge, on this case, I filed a motion for entry of judgment, Your Honor. We just need to get an order signed, Judge. We've already had a trial on it. I presented evidence. I submitted 2 proposed orders. Mr. Kaine, Judge, all the times you've been coming, he's never filed one answer. At least I've never seen one. I've never been served with anything from him. So at this point, Judge, I'm just entitled to judgment as a matter of law. He hasn't filed anything. He never filed any pleadings. And so we've had a hearing on this. I submitted 2 proposed orders. The first one is just to make the temporary orders final and just bring finality to this case. And the second order I submitted was one where I believe that Mr. Kaine was making in excess of the guidelines, which would make his child support 1,610 according to my calculations. And the other one was just to make the temporary orders final at 880, Judge. So we just wanted to see if you would just sign one or the other and just bring finality to the case, Judge.
Let me get a response from Mr. Kaine, and then I have questions for each. Mr. Kaine, response?
I did submit documentation and the Thomas Reuter stuff. That's where I was told to submit anything.
All right. So these are the questions I have. I'll ask Mr. Cantu first, and then I'll follow up with the questions for Mr. Kaine. Mr. Cantu, the court recalls multiple hearings and a lot of information.
Yes, sir.
This case wasn't straightforward, right? I mean, usually 99 times out of 100, people submit their black and white financial information, and the court assesses child support based on the calculation as required by law. In this situation, Mr. Kaine's finances aren't as clear-cut as in many other cases. So the parties agreed to submit documentation that allowed the court to assess what the correct calculation of child support should be, if any should be modified. In that interim, or I should say thereafter, the parties did file information. The court received, reviewed, and considered all of that information and then the court issued an order requesting additional information. I guess let me ask this question to both, and then we'll take it from there. Based on that court order, Mr. Cantu, what information was provided that allows the court to make that assessment?
Judge, to respond to that, Judge, because the discovery period had closed, I was no longer able to obtain any other information from Mr. King. He did provide to me all the information that we produced at trial as far as tax returns. Everything that he provided, bank statements that I submitted into evidence, was what the court at the beginning had based its temporary ruling to make to increase the child support. After we had the trial and I submitted everything that I could, I no longer was able to get anything other than what I submitted as evidence there. So the discovery period had closed. I couldn't serve with anything anymore. So I just wasn't able to get anything else for you, Judge.
Well, and that's a perfectly valid and honest answer, and I certainly appreciate that. So then, before I follow up with that, let me get Mr. Kaine's response. And I think I sent the order to both Mr. Kaine. The information requested by the court, was that information provided to the court?
Yes, sir.
All right. And my follow-up question then, Mr. Cantu, then based on the information that you submitted and based on the information, evidence, and testimony provided to the court, what is Ms. Medina's request, your client's request, and how is it supported by the information in the record?
So, again, he hasn't, I understand what he's saying, that he might have, I guess, produced it. I don't even know how he did it because I wasn't served with anything he produced. What I will respond to the court is I'll say, look, Judge, based on what I had to work with, the court did make a finding that there was enough there to at least raise the child support, to 880. It was 500 and something. The court raised it to 880, which we're okay with that. However, on trial, when it came to trial, we were here for about 6 hours. Based on what I presented, based on just one withdrawal that Mr. King made, which was in the evidence, which showed there was one withdrawal that he made, which converted into income of $450,000. He has the potential and earning capacity where that would put him over the guidelines, and then that would put his child support, according to what I have, at 16 and 1,610 a month. We would ask that the court, based on what we've submitted, what was presented at that trial, to increase it to that amount. If the court does not believe it can, then I would just request that based on the findings the court made at the temporary order hearing, just to make that order final and leave it at 880. I submitted 2 proposed orders, and the court can sign one or the other. And so,
and that was the court's final question. The difference between the first proposed and the second proposed order is
one order is at 1610 and the other is at 880.
Oh, I understand.
Yes.
Mr. Kaine, court yields the floor to you. What response, if any, would you like to make?
So Mr. Cantu said that the 450,000 was income, and it wasn't. And I submitted the documentation showing that 450,000 went from one bank to another bank to pay payroll that we had at the time. And then we lost that job and went into bankruptcy and still going through that as well. But I submitted that documentation showing that. I submitted too on the calculations. I'm so far behind on everything now. Everything I get, we had a company that we did government contracts. So anything I get is going to them because of losing that job and going through the bankruptcy. I'm actually going through a divorce well, and I submitted all that documentation for this hearing.
You're going through a divorce and you submitted that documentation?
Correct.
How would that be relevant to this proceeding?
Because I've got child support that they temporarily ordered, which is what you had done based on Mr. Cantu's statements and mine. You said temporarily we would set it at 880.
Right.
And we submitted the rest of the documentation supporting, I guess you would say, my side versus his side of what child support should be set at.
So
I-
respond to Mr. Cantu. Mr. Cantu says to the court that the court has sufficient information evidence in the record to set child support based on those transfers at $1,610. He says, and even if the court doesn't deem that as income, that there is sufficient information to set it at $880. Please respond to that.
There's not. I submitted all my tax returns and all of my bank statements. Mr. Cantu's saying that the $450,000 transfer is the justification for the 1610, and it's not, because it's not income. That $450,000 was transferred from one bank to another bank to pay out, and I submitted that as well in bank statements. And I've submitted all my tax returns, and we're showing a loss. Mr. Cantu said, well, how are you living if you're not making any money? And I said then, and sent the documentation in on loans.
Well, I understand that, but to his point, let me see if I can try to quickly, I'm trying to get an answer to give you a fair shot at this hearing. His statement to the court is the court has and should set child support at $1,600. But even if Mr. Kaine is right, and that isn't income under the law, then child support should at least at the minimum be set at $880. What is your response to that? And as a follow-up, if you disagree with that, what then do you believe the evidence shows child support should be set at?
So the 880 is what you had actually done a calculation on, based on Mr. Cantu saying that I had the potential to make an income to increase the child support. And that's where I submitted saying that, I'm doing everything I can now and can't pay it. And if that's the case, because I don't have any income that I keep, so to speak, minimum wage, and I honestly can't even afford that.
Final question, Mr. Kaine. You said you were going through a divorce. In what state is that?
Wisconsin.
Now, as part of that family law proceeding or any other family law proceeding, are you responsible for the payment of child support to any other person other than the child in this case?
Yes, sir.
How many?
One.
So one child here and one child in the Wisconsin court?
Correct.
And in the Wisconsin court, and this isn't binding on the court, I'm just trying to get a picture of what is going on. In the Wisconsin court, are you ordered to pay child support?
Yes, sir. It's a temporary order.
Might find themselves in the same position we're in. So in that temporary order, what amount, if any, are you ordered to pay in child support?
That was set at, and I submitted that. I think it's $760 on temporary orders. And I don't have an attorney in this one either. They based that on the last year that we showed a profit, I guess you could say.
Well, like I said, that whatever happens over there isn't binding on this court, other than the application of Texas law that says that you should get some credit. In other words, if you have a child here and one in this court, one in that court, but you start to see a pattern, Mr. Kaine, about how the law universally applies everywhere and how the rules of evidence and the standards set tend to flow in the same direction. It sounds like the orders of this court, at least on a temporary basis, are pretty consistent, if not similar, with the Wisconsin court. What I'm trying to gauge is whether we are so far off, too high or too low. And it sounds like, based on the evidence that you submit, courts
The-
tend to reach very similar outcomes.
The
I
court
tell
here,
you what, I'm going to take this, Mr. Cantu and Mr. Kaine, as a kind of, and I'll construe this not only as a motion to enter, but I will reconsider to review and reevaluate based on Mr. Cantu's request to set, based on the evidence and testimony, at $1,610. And in the alternative, to be consistent with the court's previous finding at $880. And then I will temper that with Mr. Kaine's request to set at minimum wage, and I will take into account all of the evidence testimony submitted to the court. And I will sign off on one of the orders. And if the findings of the court are different from the child support calculation in one of the orders, I'll scratch it out and write it in. Mr. Kaine, is there any other information, evidence, and testimony that the court should take into consideration?
I don't have any documentation. Our next court here in Wisconsin is mid-May.
Sure.
And at that point, the 880 was temporary orders until the final hearing. At that point, I actually won't pay any child support.
Under temporary orders in the Wisconsin court, you're set at $760. You think at final hearing, you'll be ordered to pay nothing.
Correct.
That's an impossible assessment for you to make, because no person can infer or definitively say what any court's going to do. That would be not right.
It's
So,
because we have 50-50 custody.
many people think that, and I can't speak for any Wisconsin court or judge, but just because people get, I just did that. You just heard that. If you were paying attention, people said 50-50, and I said absolutely not. One person is paying child support. So it's very difficult for any person to definitively say, I know exactly what the court's going to do. And I won't speak for any court outside of this jurisdiction or outside of the state, but I can certainly speak on behalf of the judiciary, and it is impossible for any person to say, I know how any court's going to rule. But
I'm going off what the judge said in the, I guess, preliminary hearing for the temporary orders.
we can kind of forecast, but things change at the final hearing. I understand that. All right. Ms. Flores, I'm going to give the court its own orders due dates that I can review, and it'll be our own internal deadline. Orders due on
March 30th.
All right. Anything else put on the record on this case, Mr. Kaine?
No, sir.
All right. Anything else on the record, Mr. Cantu?
Judge, if you would like, Your Honor, what I can do is both orders that I submitted for your consideration are identical in nature except for the child support amount. I can submit a blank one. I'll submit another one with a blank one, and if you are going to insert your own amount, then you can just write it in the blank.
Sure, and I'll tell you, and I'll disclose to you, Mr. Cantu and Mr. Kaine, what the court is going to review. I'm going to see why the court should deviate from that 880, and what I need to know and assess is whether that 880 contemplates one child before the court and one child outside of the court. I don't know that I did that at temporary orders, but it sounds like if the court didn't do that, then it's very likely that that child support will be almost identical to the Wisconsin court, which shows you that there is consistency even across state boundaries. But that may change. I don't know until I assess. All right, Ms. Medina, I need to give you an opportunity. Anything you want to say, or do you have any questions? Unmute your device, please.
Yes, good afternoon. The only questions that I have are how will his, how will he end up paying since he's already backed up close to 25,000? I mean, he has made no minimal payments.
How he pays is not generally the court's concern. If he doesn't pay, then you should talk to your lawyer about seeking remedies on behalf of your mutual son.
Well, the only thing is that when I talk to the Attorney General, they tell me that the only reason that they cannot do anything in behalf of my case is because it's not closed yet. And this case has been going on for, I think, more than a year. Or
Right,
I don't,
the court is going to sign an order on March the 30th, and take that order, or they process it automatically. They're going to make all the calculations, and then they'll take it from there. If you have any questions, then you can either reach out to your lawyer or call the Attorney General's office to see where this is in the process.
okay, I just want him to be held responsible. That's it.
Understood, Ms. Medina, Mr. Kaine, I wish you both well. More importantly, I wish your son all the best. Good luck to him.
Okay, thank you.
Any other cases for Mr. Cantu?
That is all for Mr. Cantu.
Have a great day, counsel.
Let's see, Judge, thank you.
Likewise.
Case Attorney Jose Luis Castillo, page 7, number 18.
Octaviano Garza Jr. versus Veronica Garza, cause number 2025 FLB 1695C3. Court marks Mr. Jose Luis Castillo, present in person. Good morning, counsel.
Good morning, Your Honor. Your Honor, on this case, I did file a motion for continuance. Judge, there is service. There has been no file on record or no answer on behalf of the respondent, Judge. However, the parties are still attempting to reconcile, Your Honor, and hence we're asking for at least 90 days.
Very well taken. Court has signed off on that order. Ms. Flores, give us a setting in 90 days, please.
That'll be June the 16th at 2 p.m.
All right. Any other cases for Mr. Castillo?
That is all for
That's all
Mr.
I have, Your
Castillo.
Honor.
Have
I
a great
appreciate it,
day.
Your Honor.
Yes,
Thank
sir.
you,
Good to
Judge.
see you.
Likewise.
Next case, Attorney Guillermo del Barrio, page 6, number 17.
Crystal Marie Morales versus Christopher Danny Walker, cause number 2025 FLB 1691C3. Good morning, Mr. Del Barrio.
Good morning, Your Honor.
Court martial present in person. Good morning, Mr. Ornelas.
Good morning, Your Honor.
Court martial present and participating by video conference. Are you Christopher Danny Walker? Welcome to court, Mr. Walker. The court martial present in person. The person to your right is your lawyer. Speak into the microphone and tell the court, are you Crystal Marie Morales? Court has heard yes, sir. Welcome to court, Ms. Morales. The court martial in person. As you can see from this screen and device, your lawyer is present by video conference. Counsel, what is the announcement?
Your Honor, we do have an agreement. Mr. Ornelas, I'm not sure if he's present via Zoom.
I am, Your Honor.
Oh, there he is. We have an agreement. He dropped off, they had filed an annulment, and both parties have signed off and both attorneys have signed off, Your Honor. I do believe we can prove it up really briefly, real quickly.
Ms. Morales, Mr. Walker, would you each raise your right hand? Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Both have answered yes. You may lower your hands. Mr. Ornelas, you're the petitioner. Will you be asking questions?
I can, Your Honor. If I may, Crystal Marie, would you state your full name for the record?
Crystal Marie Morales.
And you are married to Christopher Danny Walker, is that correct?
Yes, ma'am.
And Crystal, you are a resident of Webb County in the state of Texas, and you have been for the past 90 days and 6 months, is that correct?
Yes, sir.
And so is Christopher Danny Walker, is that correct?
Yes.
Is it correct that both of you were married on the same day that you got your marriage license?
Yes, sir.
Yes, Your Honor. Yes, sir.
And
Mr.
72
Walker,
hours.
give me one second. Just hold up on your answers because right now, Mr. Ornelas is asking questions to Ms. Morales. Ms. Morales, I just want to make sure that Ms. Morales is audible.
Ms. Morales, if you could speak clearly to the record, because it's being they're taking all our words down, so we have to be careful with that.
All right, go ahead, Mr. Ornelas.
All right. And When you got married on the same day you got your marriage license. Is that correct?
Yes, sir.
Both parties feel that it was impulsive and that they didn't have time to fully consider their decision. Would that be a fair assessment?
Yes, sir.
And both parties are asking that this marriage be nullified.
Yes.
Now, Crystal, you all did not adopt any children during this time of the marriage. Is that correct?
No, sir.
And there are no children that are expected of this marriage.
No, sir.
No party is holding each other responsible for this. Is that correct?
Yes, sir.
And you're asking this honorable court to annul your marriage?
Yes, sir.
No further questions, Your Honor.
Anything on cross-examination, Mr. Del Barrio?
No, Your Honor.
Questions for your client?
Yes, real briefly, Your Honor.
Go
Mr. Walker, can you please state your name for the record, your full name?
Christopher Danny Walker.
And Mr. Walker, you heard what Mr. Ornelas asked his client and what she responded. Is that correct?
Correct.
Do you have anything to add to that?
No, I don't.
Okay, so the fact that y'all got married the same day that you got your marriage license is correct as well, right?
Yes.
There's no children born to the marriage, adopted, or any expected, correct?
No children.
Okay, and you are also asking the court to annul this marriage, is that correct?
Correct.
And Mr. Walker, you've I've gone over the agreed decree of annulment, is that correct?
Yes, sir.
And you've signed it, is that correct?
Correct.
And Your Honor, I've got no further questions, Your Honor. We're just asking the court to grant the annulment.
Mr. Ornelas, any cross-examination questions for Mr. Walker?
None, Your Honor. Just to state on the record, they each have their own property. There was no commingling. Each one keeps what was in their property. That is all.
All right. Are there any proposed orders, or would you like me to?
Your Honor, I do have an order, but I would imagine you'd like me to e-file it. Or
No,
I can take.
on the day of final orders, I will sign.
Oh.
Has Mr. Ornelas had a chance to review those?
He prepared them,
I
Your Honor.
have, Your Honor, and I drafted them.
Yeah, he drafted them. He's dropped them off in my office. They've signed it, and we've signed it, Your Honor.
Only require the for evidence and things of the sort, but final orders, I will take the day of. All right, Ms. Morales, Mr. Walker, in your case, cause number 2025 FLB 1691C3. At this time, the court finds that it has jurisdiction over this case, meaning this is the proper court form and venue to consider your request to annul your marriage. The court finds that you entered into marriage. That marriage, however, was entered into less than 72 hours after receiving your marriage license. The court finds that no children were born, adopted, or expected. The court finds that there is no community to property to divide. The court hereby grants your request and your marriage is hereby annulled. The court has received, reviewed, and considered the proposed orders. They are in due form. I have signed them and I am tendering the original to the clerk's office. Ms. Morales, do you have any questions for the court? Mr. Walker, do you have any questions? I wish you both well. Have a good day.
Thank you, Judge. Might be excused. I believe that's all I have.
It's good to see you. Have a great day. Any other cases
Your Honor.
for Mr. Ornelas?
Your Honor, thank you so much, and thank you, your staff, and opposing counsel was a gentleman. I really appreciate the court's help.
Good to see you as well, Mr. Ornelas. Have a good day.
Likewise. Thank you, Your Honor. Be excused.
Yes, sir.
Next case, Attorney Eduardo Romero, page 3, number 6.
Luis Javier Flores versus Ana Cristina Garza, cause number 2020 FLB 1698C3. Court marks Mr. Romero present in person. Ms. Garcia, are you present?
I am, Your Honor. Good morning.
Court marks you present by video conference, and court marks Ms. Soto present by video conference. Good morning to all.
Good morning, Judge.
Luis Flores, are you present?
Yes.
Welcome to court, Mr. Flores. Court marks you present by video conference. As you can see and hear from your device, your lawyer is present in court. Ana Cristina Garza, are you present? Court finds Ms. Garza not, is this Ms. Garza behind you, Ms.?
Yes, Judge. Yes.
Oh, welcome to court, Ms. Garza. Court marks you present by video conference from the office of your lawyer. Sixth setting, Mr. Romero, Ms. Garcia.
Judge, we're ready to proceed.
And is this an agreement or is this a contested matter?
It's an agreement, Judge.
Mr. Flores, Ms. Garza, would you both raise your right hands? Do each of you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
Yes.
Ms. Garza?
Yes, sir.
All right, both have answered yes, you may lower your hands. Mr. Romero, Ms. Garcia, go ahead.
Judge, I'll make the stipulations on the record and then ask a couple of questions of my client. That's acceptable for the court.
Yes.
The parties will be named joint parent managing conservators of the minor child. Mother will have the right to determine the primary residency of the boy. With regards to visitation, it will be set on an extended standard schedule. With regards to the first visit, overnight visit, it will be this coming Saturday. He will be picked up by father at 10 o'clock at mom's house, and he will be returned the following Sunday at 6 o'clock. And thereafter, the extended will kick in. With regards to child support, Judge, given that Mr. Romero and I are coming up with different numbers, we've agreed to have the OAG's office run the calculation, and we will agree to abide by that calculation. With regards to, and that will begin April the 1st. With regards to retroactive child support, Judge, that period of time will run from December of 2024 to February of 2026, based on the calculation to be determined by the AG's office, and that will be duly inserted into the order. Health insurance will be a reimbursement from Mr. Flores to Ms. Garza, and that reimbursement will be in the total amount of $161.23. That includes medical, dental, and vision. With regards to I think that is it. Mr. Romero, have I missed anything?
I don't believe so, unless, I mean, you want to include the right to designate and, I mean, the right to designate an adult to pick up the child. I don't know if we need to stipulate anything else.
No, I think we've run through everything. The add-ons we'll do in the order thereafter. Judge, if I can ask some questions of my client.
You may.
Ma'am, state your name for the record. Ana Garza. Ms. Garza, you've heard the terms and conditions I have just read into the record. Yes. Do you agree that these terms and conditions are in the best interest of the child? Yes. Are you asking the court to grant this order? Yes, sir. Pass the witness, Judge.
Ross?
No question, Your Honor.
Your client?
Yes, Mr. Flores.
Yes.
Yes, can you please state your name for the record?
Luis Flores?
You've heard the stipulation read into the record. Are you in agreement?
Yes.
And is this in the best interest of your child?
Yes.
And are you asking for the court to approve it?
Yes.
I'll pass the witness, Your Honor.
Cross?
Nothing, Your Honor.
Approved. All right, Ms. Flores, Mr. Flores, Ms. Garza, in your case, cause number 2000. Oh, I'm sorry. Ms. Soto, anything to add?
Your Honor, I'm glad the parties were able to reach an agreement.
Thank you.
Sorry, Al.
Ms. Garza, Mr. Flores, in your case, cause number 2020 FLB 1698C3, the court finds that it has jurisdiction. The court has heard your agreement stated on the record, confirmed by you, told to the court by your lawyers, and confirmed by each of you under oath. The court hereby adopts and approves your agreement in full and finds that it is, in fact, in your child's best interest. These are the orders of the court, and the orders are due honor before March the 30th at noon by submission. Mr. Flores, do you have any questions for the court?
No.
Ms. Garza, do you have any questions?
No, sir.
Mr. Romero, anything else to add?
No, Your Honor.
Ms. Garcia?
Nothing.
Ms. Flores? Ms. Soto? That's
None,
twice.
Your Honor. Thank you.
Thank you all. Have a great day.
Thank you, Honor.
Thank you.
Call Your Honor, in person, Attorney Brenda Anderson, page 9, number 24.
Vanessa Medina versus Alcer Conrado Medina Jr., cause number 2026 FLA 26C3. Court marks Ms. Anderson present in person. Mr. Arce is now also present in person. Ms. Vanessa Medina is present and participating by video conference. We'll pause on Spanish language interpretation until after the announcement. Mr. Medina, Conrado Medina, are you present? Court finds Mr. Medina not present. Counsel, go ahead.
Your Honor, in this case, if the court recalls, there's a companion case in 2021 FLA 1017C3, which was the original divorce. A subsequent divorce was filed by Ms. Medina, and I need to stop. Okay.
Sí, recuerdo, señores, si recuerda, hay un caso acompañante, en este caso que es el 2021 FLC 1017C2.
C3.
C3.
And that was the divorce of the parties.
Y ese fue el divorcio de las dos partes.
We are here set today on a subsequent divorce filing filed by wife.
Estamos aquí para un juicio subsecuente de un caso que fue sometido por la esposa.
The parties have agreed that this case should be non-suited, and we will be addressing a motion to modify that has already been filed in the prior divorce case.
Las dos partes están de acuerdo que ese caso no debe ser continuado y vamos a ver el caso que fue modificado, que fue introducido ya al juzgado.
A motion has already been filed, Judge, in that case. We are just pending to receive a setting. A motion and fiat were filed already.
La petición ya fue solicitada al juzgado y solamente estamos esperando una fecha.
Mr. Arce.
Your Honor, I believe that's why Your Honor had given us a pretrial judge just to iron out those issues. We don't have a problem with non-suiting the second divorce, Judge, being that we do feel the modification.
No tenemos ningún problema con el caso, simplemente creo.
Yes, Judge, basically, we feel that the modification should also resolve the same issues as a new divorce would have, Judge.
Creemos que la modificación va a resolver los mismos asuntos que un divorcio nuevo resolvería, su señoría.
So we're just asking this court set that modification, Judge, and then ultimately we'll submit that non-suit, Judge.
Y estamos pidiendo al juzgado que someta la fecha para la modificación y nosotros introducimos los documentos para que ya no se proceda en el otro caso.
I'll tell you what. Go ahead.
And just to clarify, this new divorce is being non-suited because there is no marriage, so a divorce is not necessary.
Estamos pidiendo que no se continúe con este nuevo divorcio porque en realidad no hay un matrimonio.
And the issues that are pending before the court are issues that can be resolved, or pending between the parties are issues that can be resolved in the other case.
Y creemos que los asuntos que están pendientes entre las dos partes se pueden resolver en el otro caso pendiente.
Let me do this.
Déjenme hacer esto.
I'm going to schedule the petition to modify.
Voy a someter la fecha para la modificación.
On April the 2nd at 9.
Abril 2 a las 9 de la mañana.
That's the trial on the merit setting in this case.
Esa va a ser la fecha para el juicio en los méritos en este caso.
Ms. Anderson, Mr. Arce, I just want to confirm that at this juncture, it's highly unlikely that any person will allege a common law marriage on April the 2nd.
Y señora Arce, señor Arce y señora Anderson, nomás voy a confirmar, ninguna de las dos partes está pidiendo que sea un matrimonio común.
Yes, sir.
Correct.
Correcto.
Okay, then we'll just set the modification on the same day as this final hearing. That way you don't lose that setting.
Yes, sir.
Y vamos a poner la modificación en la misma fecha para que no se pierda la fecha.
Anything else on this case, Mr. Arce?
Judge, there was some issues as to child support and visitation, Judge. I've conferred with counsel. We're trying to iron those issues out amongst ourselves, Judge, to have that resolved by the court date. Judge.
Sí, señoría, hubo unas situaciones sobre manutención y visitas del menor, pero creo que nosotros lo podemos arreglar entre nosotros.
Very well, Ms. Anderson.
That's correct, Judge.
Es correcto, su señoría.
Ms. Medina, do you have any questions for the court?
Señora Medina, ¿tiene alguna pregunta para el juzgado?
No, todo está bien.
No, everything's fine.
All right, keep in contact with your lawyer.
Manténgase en contacto con su abogado
Mr. Medina will do the same.
y el señor Medina va a hacer lo mismo.
Wish you both well. Have a good day.
Les deseo lo mejor, que tengan buen día.
Gracias.
Any other cases for Ms. Anderson or Mr. Arce?
That is all for both counsel.
Your Honor, I had another matter with Mr. Chu. I'm not sure. I believe that was reset, Your Honor. It was a submission of an order.
Ms. Anderson, it's good to see you. Have a good day.
Thank
You're excused. Ms. Flores, the page and case?
Page 3, number 8.
Mr. Arce, the court called that case at 9:31. Mr. Chu was present. Mr. Garcia wasn't present, but he's here now. Neither one of the parties were present. The court has set this for orders due on March the 30th by submission.
Thank you, Judge. That's all I needed.
Great
That's
to,
all I have. Maybe.
great to see you. Have a great day.
Likewise, Judge. Thank you.
Recall, Your Honor, page 6, number 16, with Attorney Luis Antonio Figueroa.
María de Los Ángeles Mirez versus Jerónimo Ibarra, cause number 2025 FLB 1514C3. Court marks Mr. Figueroa present in person, Mr. Garcia present in person. María Mireles, Jerónimo Ibarra, are you present? Court finds parties not present. Counsel, go ahead.
Good morning, Your Honor.
Morning.
Julio Garcia Junior here for Mr. Ibarra.
Tony Figueroa from Mrs. Mireles. We filed a motion for continuance based on the grounds that we've been exchanging discovery voluntarily between us. We do need an appraisal of the homestead, and also Mr. Garcia is thinking of getting a valuation of a business. So we need a little bit of time to get all that squared away, and we can come back or try to work this case out.
Mr. Garcia?
That's correct, Your Honor. If for whatever reason that we can't reach those type of accommodations amongst ourselves, we may consider maybe going to a mediator for a half day if necessary. But really, there's no children involved. It's just the division of property.
That's correct.
Court has received, reviewed, and considered the written motion for continuance. The court finds that it's necessary to appraise a homestead and to value a business. Let's do three things with that info, Ms. Flores. Give us a final pretrial hearing in 60 to 90 days.
That'll be June 2nd at 2 p.m.
Give us a final hearing 30 to 45 after that.
August 11th at 2 p.m.
All right, I'm going to give you two more dates. The other dates are the appraisals and valuations are things out of our control. How long professionals take to do that, and then depending on the complexity of the business or the home. So you all have a deadline to agree to those persons by March the 26th. If you don't, then your orders due on that, the court will order it on March the 30th. So agree to either or both, and if you don't, just file proposed orders. I will pick something out of a hat to help the parties. And then if there is no agreement by June the 2nd, which is the date of your pretrial hearing, agree to a mediator and select a date and let the court know what that date is, and that should be done. The mediation should happen before August the 11th. And just apprise the court, we agreed to one person and it's set on this date.
It shouldn't be a problem, Judge, especially for the home or the mediator. I think the trick is going to be for the business. Obviously, we'd like to keep our costs low, and so we're going to try and see if we can find somebody who's accommodating.
Those are always the stickiest because, like I said, we can control ourselves, we can't control other people, and professionals will take their time to do a good and thorough evaluation.
And I don't think it shouldn't be very difficult for somebody to come in to do evaluation. It's
a simple business of a daycare for children, so we can provide tax returns, they can see their monthly.
And obviously, this would be used in order to either offset, give credit, or do a proper division, I guess, as it were.
No, the court appreciates the optimism. Thank you both.
So,
anything else on this case, Mr. Figueroa?
No, yeah.
Mr. Garcia?
No, Your Honor.
Always good to see you both.
Yes, sir.
Have a great day.
Maybe excuse Your Honor.
Yes, sir.
Thank you.
Next case online, Your Honor, Attorney Madeline Lopez Escoto, page 2, number 3.
Gladina de los Santos versus Eduardo de los Santos, cause number 2018 FLA 500C3. Court marks Ms. Escoto, President participating by video conference. Good morning.
Good morning again, Judge. Madeline Escoto for Mr. De Los Santos. He is not present, Judge.
Court marks Mr. de los Santos not present. Attorney Alberto Martinez King, are you present? Court
Good morning,
counsel,
Judge.
Court finds counsel present and participating by video conference. Good morning. Galina de los Santos, are you present?
She is not present.
Court finds petitioner not present, and court marks Ms. Catherine Garcia, present and participating by video conference. Counsel, go ahead.
Judge, we filed an agreed verified motion for continuance on this case. I owe Mr. King some bank statements to reflect the credits my client believes he should be entitled to when the parties were living together. So those are going to be sent to him and Ms. Garcia so that that'll give us some time to start exchanging settlement offers.
Mr. Martinez King?
That is correct, Judge.
I'm sorry, and you said the two things that you had pending and outstanding were what two things, Mrs. Cotto?
The bank statements, which I have in my office, Judge, so I need to send those to him. And then we just need to exchange settlement offers based on those numbers.
Now, I'll just put two things, Mrs. Cotto and Mr. King. The only reason the court didn't sign off on this yesterday, the court reviewed for this. I just want to put specific dates to give the parties benchmarks to work towards. And I know it's going to happen probably without the court's intervention, but I do want it in the order. Ms. Escoto, how much time would be reasonable and necessary to forward to Mr. Martinez King the bank statements?
I should have the unredacted bank statements by today. My office just put them in order this morning. And then he's going to get a second batch, probably, I want to say sometime next week, which highlights all the payments made by husbands towards the household. And then my goal is that hopefully he can review that and send me an offer of settlement no later than the end of March.
Sure, but I'm about to write in a date.
Okay, that's fine.
But you tell me.
Today for the bank statements, next Friday for the highlighted sections of the bank statements, because there's 3 years worth. And then, Mr. King, I don't know how long it'll take you to review them and send me an offer based on what I send you.
I think for the most part, we could probably get a 1 week turnaround on those. I know she's pretty active on her case.
Court has signed off on that motion for continuance. It's granted, and the court has written in bank statements are due to Mr. Martinez King on or before March 6, 2026, and highlighted statements on or before March 13, 2026. Offers and counter offers shall be exchanged before March 27th, near the end of the month, 2026. Well taken, Ms. Flores. Give us a. This was a final hearing. Give us a final hearing date, please.
April 16th at 2 p.m.
Anything else on this case, Mrs. Cotto?
No, Judge, and I'll copy Ms. Garcia on the statements that I sent Mr. King.
I apologize, Ms. Garcia. Anything to add?
Your Honor, just one thing, there is a request for modification before the court. Being that it's already March, we would ask that Mr. De Los Santos's tax return, if any has been filed, and all of his 2025 W-2s or 1099s be produced as well.
I think the problem with that is I really don't have a problem with that, but I don't know if Ms. Garcia remembers, this is the case that dad has one child.
Correct.
And mom has the other, so we would request the same from Mr. King as to whatever her earnings are,
If I understood correctly, and if this isn't what you're saying, you need to correct the court, Mrs. Cotto. Mr. Martinez King, Mrs. Cotto says there is no objection so long as it applies equally to all. So she doesn't object as long as you don't. Mr. Martinez King, any objection to providing that financial information to Ms. Garcia at the AG's office?
No, we wouldn't object to that.
Was that a correct restatement of your position, Mrs. Cotto?
Yes.
All right. All right, well taken by all, and nothing is objected to, everything is agreed to. Give that information to the Office of the Attorney General's office as soon as possible. And then we'll come back on April the 16th at 2. Anything else on this case, Mrs. Cotto?
Nothing further, Judge.
Mr. Martinez King?
Not on our end, Judge.
Ms. Garcia?
No, Your Honor, nothing further.
Thank you all.
Mr. King, further down the line, Attorney Escoto, page 4, number 9.
Irma Ramirez versus Ismael Ramirez Jr., cause number 2025 FLA 929C3. Court marks Mrs. Cotto, present and participating by video conference. Ms. Soto, present and participating by video conference. Ms. Garcia, Leticia Garcia, present and participating by video conference. Irma Ramirez, Ismael Ramirez. Any parties present? Court finds no parties present. Counsel, go ahead.
Madeline Escoto for Irma Ramirez.
And Elisa Marzo here for the respondent, Ismael Ramirez, Your Honor.
Judge, it looks like we're going to reach an agreement on this case, but we did file a verified motion for continuance just because father has recently relocated to San Antonio, and Ms. Garcia just needed to confirm with him what these visits are going to look like in the future. And Ms. Soto owes me a new current pay stub from this new job so that we can memorialize our understanding of the agreement.
That's correct, Your Honor. My client received a job offer and has just started this Monday. I did send Mrs. Cotto his offer letter stating his salary and the rate of pay. She requested a pay stub. That won't happen until maybe about 2 weeks from now. I should be able to give her his first pay stub.
And that's exactly, and I'm just repeating myself from the last couple of cases. The only reason I didn't automatically sign off on this one was for that reason, Ms. Soto. I know that it's likely to happen, and I know that both of you think it will, but you're relying on the work of other persons, that's your client, to give you that information. So let me take this one by one. For the pay stub, I'm going to write into the order, Ms. Soto, a definitive deadline to tender that to Mrs. Cotto. How much time would be reasonable and necessary to tender that information?
So he gets paid semi-monthly, Your Honor. He just started on Monday, so I would imagine that he's going to have his first complete pay stub by the end of this, maybe by March 20th.
So looking at a calendar, ostensibly, if he would have a pay stub on the 20th, would a week or more be reasonable to tender that information?
They're correct. I can probably give it to her the week of, anytime in the week of March 23rd, Your Honor.
All right.
Just so I can make sure that I get it in my possession from my client.
Did we lose Ms. Soto? Oh, no, she's back. Re-highlight, please. And then the second issue was, and Ms. Garcia, unfortunately, I don't think is logged in anymore, but fees are due to Ms. Garcia?
Yes, Your Honor, each party owes $750 to her.
That is correct, Judge. And so we wanted to make sure she got paid also before the end of the case, Judge.
That's exactly what the court was going to say. Any objection to the court, I'm writing things into the order, to writing in that outstanding ad litem fees shall be paid prior to the final hearing?
Yes,
None,
Judge.
Your Honor.
That's fine.
And I was going to put in a third sentence for the exchange of settlement offers. I have zero doubt that Ms. Soto and Mrs. Soto, that I'm confident both of you are going to do that. All right. So I've granted the request. I've signed as granted, and I've written in respondent's pay stub is due to Attorney Escoto honor before March 27, 2026. Outstanding ad litem fees shall be paid prior to the final hearing. Ms. Flores, give us that final hearing date, please.
April 16th at 2 p.m.
Anything else on this case, Mrs. Soto?
Nothing further on this one, Judge.
Ms. Soto?
Nothing on this case, Your Honor.
All right. Thank you both.
Thank you.
Down the line. Ms. Madeline Lopez Escoto, page 4, number 10.
Joshua Sass versus Cynthia Pacheco Martinez, cause number 2025 FLA 1305C3. Court marks Mrs. Cotto present and participating by video conference. Cynthia Pacheco Martinez, are you present? Court finds Ms. Martinez not present. Joshua Sass, are you present? Court finds Mr. Sass present by video conference. I'm going to ask that you unmute your device, please, sir. There is a red
there we go. Sorry, sir.
Are you Joshua Sass?
Yes, sir.
Welcome to court, sir. The court martial president participating by video conference. Do you have a lawyer?
No, sir.
Are you going forward without a lawyer?
Yes, sir.
Court marks you self-represented. Mrs. Cotto?
Judge, I sent, Mr. Sass sent me his W-2 and his current pay stub. But then I found out yesterday that he may have, and there's Ms. Pacheco, Judge, that he may have moved jobs. So I just need to confirm with him, is he still at his previous job or is he at a new job?
New job.
I'm sorry, he said new job, Judge?
Yes.
Yes, ma'am. New job.
And so, does Mr. Sass, do you have a?
Mr. Sass, let me ask you some questions. Don't worry about interpretation until we get to the end. I'll summarize all of this.
She understands, Judge. It's just speaking that she has a difficulty, but she understands everything that we're saying today.
Ms. Pacheco, I'm going to ask that you unmute your device and tell the court, are you Cynthia Pacheco? There's a microphone button at the bottom left of your screen. Press that button, please.
I'm sorry. Yes, I am.
All right. And do you understand everything that's being said?
Yes.
If you have any questions, please let the court know.
Okay, thank you.
Mr. Sass, you have a new job?
Yes, sir.
How long have you been at that new job?
1 month, sir.
Have you received your first paycheck from that job?
Yes, sir.
And when do you expect to receive the next paycheck?
I get paid weekly, sir. So every Friday. So tomorrow I will receive my 5th paycheck.
All right. So if you receive your 5th paycheck on March the 6th.
4th or 5th, sir, I think.
Sure. Ms. Flores, give us the next hearing date, please.
April 2nd at 9 a.m.
All right, so I'm going to order you, Mr. Sass, to forward to Mrs. Cotto's office your paychecks until March the 20th.
Roger.
You're going to have another one on the 3rd of, I'm sorry, you said April 2nd. Right. So until March the 20th, that's going to be your last. So send everything that includes and including the one on the 20th. That'll give her some opportunities to run some numbers, and both of you can make arguments as to what the number should be set at. Do you have any questions on Mr. Sass?
Negative. I just wanted to advise that the child support.
Mr. Sass,
and everything like that. That information.
Unfortunately, your bandwidth is very low and you're cutting in and out. Please restate what you said last.
I just wanted to, I guess, advise that child support has already been automatically deducted out of my paycheck. I've advised the Attorney General's office of my new job and all that information. Like, they're already taking child support out of my paychecks.
Well, this is a good thing, Mr. Sass, and it's good for the child or children that are involved. But, you know, from your perspective, it's good because any amount set, you're not starting behind the line, I guess, as it were. In other words, you should be, if stuff is being taken out, then you should be current or close to current, which is good for the child and for the final outcome of the case. So, but I understand what you're saying, and it's very well taken.
Yes, sir. Yeah, I should be current. I'm sorry.
Good. Ms. Garcia, I think the OAG's office is involved. Anything to add?
Your Honor, we do have a case opened, and we have the temporary orders that were signed by the court in November. They have been entered, and we are collecting child support at this time. I do believe there's a little arrearage because there was a gap in time between when the order was entered and when they started collecting, but.
Correct, Judge. And I did send Mr. Sass, Judge, an offer of settlement and updated it yesterday, but I'll update it again and send it to him as soon as he gives me all the pay stubs from the date that he started working till March the 20th. So that way he has enough time to review it.
And Mrs. Cotto, you're sending these offers ostensibly through email?
Email. I have his email, Judge.
Ms. Flores, does the court have Mr. Sass's email?
Yes, Your Honor.
Mr. Sass, it's very important, and you probably are. I just want to confirm that you're receiving those emails and you're able to view and respond to those.
I haven't checked my email probably in the past 3 days because of the technical difficulties of my phone. But yeah, I mean, as soon as I get a chance and everything like that, I'll check my email again if Mrs. Cotto sent it yesterday or today.
So, and what she's saying is once you sent all of your financial information and pay stubs, she's going to run some numbers, she's going to make an assessment, she's going to put it in writing, she's going to send it to you. You need to receive and review that and then respond to her and say whether it's agreed in whole, in part, or if you have a counter offer, and that way she can come back with whatever information the court needs to consider. Do you understand all this?
Yes, sir. I'm tracking on the court orders. I also did want to advise Ms. Garcia and the Attorney General's office that 2 years ago I was involved in a car accident, and I just got the settlement check for that car accident. So a lien was placed for $2,717 for child support arrears to my wife. So as of within the next week or two, and I'm sure Ms. Garcia will receive that paperwork pretty soon. If not, I can email that to Mrs. Coco as well.
I have nothing to add, Mrs. Cotto.
No, Judge, if that is true, then the proposal will be changed as long as Ms. Garcia confirms that those monies are to Ms. Pacheco and not the other children that he has a duty to support.
Yeah, the letter specifically says to Cynthia Pacheco, Cynthia Jocelyn Pacheco Martinez, for our daughter.
He can send it, Judge, and I'll take a look at it. Thank you, Judge.
Ms. Pacheco, do you have any questions for the court?
No, sir, I don't have any question.
Anything else to add, Ms. Garcia?
No, Your Honor.
Mrs. Cotto?
Nothing further, Judge.
All right, I look forward to calling this case on April the 2nd. Good luck to all.
Roger that. Thank you, sir.
Next case from Mrs. Cotto, page 5, number 13.
Elizabeth Flores, Jorge Armando Flores, clause number 2025 FLB 863C3. Court marks Mrs. Cotto present and participating by video conference. Rebecca Ramos, are you present? Court marks counsel Ramos not present. Give me a second while I take over the spotlighting for this hearing. Elizabeth Flores, Jorge Armando Flores, are the parties present? Court finds parties not present. Mrs. Cotto, go ahead.
Madeline Escoto, Judge, for Elizabeth Flores, this was one of those cases that was set for the submission at noon. The decree was never submitted, signed by the other party, so I filed a fiat. I did receive yesterday their signature pages. I have signed it, my clients have signed it, and so it was e-filed. We're asking that the court sign the same today.
The court has received, reviewed, and considered that agreed final decree of divorce. It is in due form, signed by all. The court has signed it and tendering the original to the clerk's office. Thank you.
Next case from Mrs. Cotto, page 6, number 15.
Arlene Caldera versus Marcos Caldera, cause number 2025 FLB 1441C3. Court marks Mrs. Cotto present and participating by video conference. Mr. Hernandez, Juan Hernandez, are you present? Court finds Mr. Hernandez not present. Parties, Arlene Caldera, Marcos Caldera. Any parties present? Court finds no parties present. Mrs. Cotto, go ahead.
Madeline Escoto, for Mr. Caldera, Judge, on this particular case, we did file the final decree of divorce. If you recall, you pronounced and rendered last Thursday, but because of the time being of the essence in wife paying the full amount of the note, we needed it signed today. And so Mr. Hernandez signed it, his client signed it, I signed it, my client signed it, and we're asking that the court approve the same.
So noted, well taken. The court has received a final decree of divorce. It is in due form and signed by all. The court has now signed it and tendering the original signed decree to the clerk's office. Thank you.
And I believe that's all I have, Judge. May I be excused?
Good to see you, Mrs. Cotto. Have a great day.
You too, Judge.
Next case, Your Honor, page 4, number 11. Attorney Loredo, standing in for Attorney David Gonzalez.
Jesse James Ortiz Jr. versus Leileni Ruby Ortiz, cause number 2025 FLA 1577C3. Good morning, Mr. Loredo.
Good morning, Your Honor.
Court marks you present. You're participating in person. Speaking to the microphone and to the court, are you Jesse James Ortiz Jr.?
Yes, sir.
Welcome to court, Mr. Ortiz. I need you to speak much louder into the microphone. Court marks you present, Mr. Ortiz. The person standing to your left is your lawyer. Court marks Mr. Martinez King, present and participating by video conference. Good morning.
Good morning, Judge.
Leileni Ruby Ortiz.
Yes.
Welcome to court, Ms. Ortiz. The court marks you present by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Mr. Loredo, Mr. Martinez, what is the announcement?
Yes, Your Honor. So we have reached an agreement with the parties have reached an agreement. We just needed one more setting, Your Honor, so that we can submit the final decree of divorce.
So you need an order's due date, but this is a divorce. Has jurisdiction been proven?
I believe so, yes, Your Honor.
Let me ask the clerk's office, is there an entry in the record?
I don't believe there is yet.
You're the petitioner, Mr. Ortiz. Mr. Ortiz, raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, sir.
You may lower your hand. Is your true and correct name Jesse James Ortiz Jr.?
Yes, sir.
Mr. Ortiz, you filed for this divorce November the 4th, 2025. On that date, had you lived in Texas for 6 months?
Yes, sir.
Had you lived in Webb County for 90 days?
Yes, sir.
Court finds that it has jurisdiction. Anything else to add on this matter, Mr. Loredo?
Nothing further, Your Honor. We just require we can get some settings, Your Honor. We do have some scheduling conflicts on March 10th, 19th, and 27th, so anything.
Well, if it's an orders due, it'll just be by submission.
Okay.
Because the court has heard by evidence and testimony here. And I guess I should give you an opportunity, anything to cross-examine on jurisdiction, Mr. Martinez King?
No, Judge.
Court reaffirms that it has jurisdiction. Mr. Ortiz, Mrs. Ortiz, the court has been informed that you have an agreement. It just now needs to be reduced to writing. These will be orders of the court that are due to the court honor before
March 30th at noon by submission.
Mr. Ortiz, do you have any questions for the court?
No, sir.
Mrs. Ortiz, do you have any questions?
No, sir.
Keep in contact with your lawyers. They're going to be preparing those documents and filing them before. You don't have to come back to court. They're just going to get filed honor before March the 30th. Mr. Ortiz, Mrs. Ortiz, I wish you both very well.
Thank you, sir.
Thank you, sir.
Any other cases for Mr. Loredo or Mr. Martinez King?
That is all for both attorneys.
It's good to see you both, counsel. Have a
Likewise,
great
Your
day.
Honor. Thank you.
Thank you, Judge.
Next case, Attorney Elisa Mar Soto, page 3, number 7.
Eric Cedillo, Adamairis Monserrat Cedillo, cause number 2024 FLA 1759C3. Good morning, Ms. Soto.
Good morning, Your Honor.
Court martial present. You're participating by video conference. Oscar Peña, are you present? Court finds Mr. Peña's device present. Eric
I'm
Cedillo.
I'm present, Your Honor.
Good to
I'm
see
present.
you, Mr. Peña. Court
Hello,
martial
Judge.
present and participating by video conference as well. Eric Cedillo, Monserrat Cedillo. Any parties present? Court finds no parties present. Counsel, what is the announcement?
Yes, Your Honor, I did send the decree to Mr. Peña. He has returned it to me and signed with his signature on it. So the attorneys have both signed off, and I'm going to go ahead and e-file that within the next hour or so.
That's correct.
All right. These are the orders that are due to the court honor before.
March 30th at noon by submission.
And I know you said you're going to do it today. I just need to put it on the court's radar so that if it gets jammed up in the process, at least it doesn't fall through the cracks. But as soon as it comes in, I will sign off on it. Thank you, Ms. Soto. Thank you, Mr. Peña. Any other cases for either?
That is all, Your Honor.
It's good to see you both. Have a great rest of the week.
Thank you,
Thank you,
Judge.
Judge.
Thank you.
Next case, Attorney Adriana Benavides Maddox, page 8, number 22.
Carlos Eduardo Vera Sr. versus Blanca Perales, cause number 2025 FLI 1487C3. Court marks Ms. Maddox present by video conference. Good morning.
Good morning, Judge. My client
Court-
Blanca Perales is also present on Zoom.
Court marks Ms. Alania present and participating by video conference. Good morning.
Good morning.
Good morning.
Are you Blanca Perales?
Yes.
Welcome to court, Ms. Perales. Court marks you present
Good morning.
by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Are you Carlos Vera?
Yes, Your Honor.
Welcome to court, Mr. Vera. Court marks you present and participating by video conference. As you can see and hear from your device, your lawyer is also present and participating by video conference. Court marks Ms. Catherine Garcia present by video conference. She's here on behalf of the Attorney General's office. Ms. Maddox, Ms. Aldana, go ahead.
Yes, Your Honor. In this case, we are still in the process of filing a letter requesting the registration of the order from Georgia. There was a divorce from Georgia that had the child support in possession and access. that's the order we're trying to modify here in Texas. But first we need to register.
I remember that, but when you say you're in the process of filing, like it hasn't been filed yet, or it's been filed and being processed over there?
It's going to be filed today because we just received the certified copy that we had requested from Georgia a while back. So now that we have that copy, we're going to file it, but I also needed to ask Ms. Maddox if she would accept service for her client or if we need to serve her client with that.
But I just been here since 9. I just need to ask. It's now 11. Do you not know the answer to that question, Miss Alanya?
If Ms. Maddox will accept service, I don't know.
It's 11. You've had 2 hours to confer, folks.
I accept service, Judge.
There's the answer. All right. What can the court do, if anything, Miss Alanya, Miss Maddox, to assist the parties to reach a final resolution?
So we were, I was waiting on this registration to happen. I reached out to Miss Saldana last week, and so I haven't received anything from her. It's her motion. And so I would ask her to send me a settlement offer, and in the absence of a settlement agreement amongst ourselves, then I would request that we be ordered to attend mediation.
Yes, thank you, Your Honor. I am sure that she is under the impression that she sent me something, but I didn't receive anything. I don't know if it was through email or a phone call, but I didn't get any messages. I am more than willing to send the proposal. If Ms. Maddox is willing to negotiate, I'm open to that. As I'm sure my client is.
Well, let me ask you both this, and obviously we can only control ourselves. We have no authority to control the actions of other persons. And what I mean by that is, once you send this request to another state and another jurisdiction, how long do you think it'll take them to process that request?
I don't think it'll take too long. It just really depends on the district clerk's workload. But then Ms. Perales has 20 days to contest the registration. So if she doesn't contest it, then that would speed things up as well. And if she does, well, it's 20 days that she has.
Same question, Ms. Maddox.
I need a chance to review and see that, I can't imagine that we would contest it, but I haven't seen what was filed and what's registered. And so I just need the opportunity to review the documents and review them with my client as well.
All right, so let's do this. Based on all of this, the court is going to convert that final hearing. It's now going to be a docket control conference on April the 2nd. So you're not losing that setting. Now, if you're ready to finalize, you can finalize on that day. I don't anticipate that that's going to happen because nobody here, as part of this process, controls the expediency of another jurisdiction. But at least on April the 2nd, you can come back to court and confirm to the court that the information has been sent, received, processed, and sent back, or not. And then we'll come back for a final pretrial hearing in 60 days, Ms. Flores.
That'll be June 4th at 2 p.m.
And the court is going to order that settlement proposals and counter proposals be sent and received and exchanged before May 29th. Ostensibly, you're going to do that next week and next month. There's plenty of time to do that, but that's a definitive deadline to exchange offers. That way you come to court for your final pretrial hearing with that knowledge of what your positions are. You'll come back for a final hearing after June the 4th on
July 9th at 2 p.m.
which means that your mediation deadline is July the 3rd. If this case would require more than a couple of hours for a hearing, you're ordered to mediation March the 3rd. If by June the 4th, there is such a strong disagreement and you're miles apart, tell the court if you can agree to a mediator. If not, I'll select one and you can mediate before July the 3rd and you'll come back for a final hearing on July the 9th. Thoughts, comments, or objections, Ms. Aldana?
I'm sorry, I just wanted to be clear. So if the parties don't agree through the proposals informally, then we will be sent to mediation. And by June 4th, we'll either agree on a mediator or the court selects one?
Right. And it's your final pretrial. So file whatever request, pleadings, and request for relief that you want so the court can make some decisions if and as necessary on that date. Yes. Same question, thoughts, comments, or objections, Ms. Maddox?
No, Your Honor, I've noted the deadlines from the court, and just for Ms. Saldana's purposes, I did reach out to confer with her last on this case in an email dated February 9th. So,
thank you, Ms. Maddox.
Ms. Garcia, anything to add or request on this case?
Your Honor, the April 2nd setting, is that 9 a.m. or 2 p.m.?
It's at 9 a.m.
Thank
you. Mr. Vera, do you have any questions for the court?
No, Your Honor.
Ms. Perales, do you have any questions?
No, Your Honor.
Mr. Vera, Ms. Perales, I hope that these dates that the court has given puts this case on a definitive track to get you to the finish line as soon as possible. But it's very important that between now and then you keep in contact with your lawyers. They're going to talk to you about this process that includes another jurisdiction. So please keep in contact with them. And I wish you both very well. Have a good day.
You too. Thank you.
Any other cases for Ms. Aldana or Ms. Benavides Maddox?
That is all for Ms. Maddox. For Ms. Aldana.
Have a great day, Ms. Maddox. Good to see you.
Thank you, Judge. You too.
And Your Honor, I have nothing further before the court this morning. May I be excused?
It's good to see you as well, Ms. Garcia. Have a great day.
Thank you. You also.
Ms. Aldana, page 7, number 19.
Jose Angel Sepulvera versus Patsy Sepulvera, cause number 2025 FLB 1699C3. Court marks Ms. Aldana present and participating by video conference. Jose Sepulvera, Patsy Sepulvera. Any parties present? Court finds no parties present. Court takes judicial notice that respondent was served with process December 11, 2025. Ms. Aldana?
Yes, Your Honor. I have conferred with my client, and he and his wife are working towards trying to reconcile. And so we're asking for additional time to give them that opportunity. I'm asking for at least 90 days more if possible.
Is there, I did this to Mr. Figueroa. What's good for one is good for all. Is there a written request?
No, Your Honor.
So when somebody reviews the file, they're going to think we just passed it for no good reason. Put it in writing, please.
Yes, Your Honor.
The request is due to the court honor before.
March 30th at noon by submission.
All right. And if granted, we'll come back for a trial on the merits on
July 18th at 9 a.m.
All right. Any other cases for Ms. Aldana?
That is all for Ms. Aldana.
It's good to see you, counsel. Have a great rest of the week.
Okay, thank you, Your Honor.
Last case on the docket, Your Honor, page 1, number 2.
Cesar Vasquez versus Denise Vega Vasquez, cause number 2017 FLA 2151C3. Mr. Trevino, Ms. Figueroa, are any lawyers present? Court finds no lawyers are present. Cesar Vasquez, Denise Vega Vasquez, any parties present? Court finds no parties present. This is an entry of judgment. Have orders been filed?
Your Honor.
All right, let's leave this on for orders due by submission, March the 30th at noon. Ms. Flores, have all cases been called on today's docket?
Yes, Your Honor, all cases have been called.
This now concludes this docket held in person and by video conference for Thursday, March 5th, 2026. The court continues to embrace the latest technology to provide safe and uninterrupted access to justice without delay. Today's docket was made possible by the appearance of parties and counsel and by the assistance, diligence, and preparation of the Webb County Court at Law 2 staff and the employees of Webb County that provide judicial support to the court. For the person still here, our interpreter, Mr. Cuellar, our clerk's office and sheriff's office, the court thanks you all. Have a great day.